Hello, I'm Mike Looney, and I'm the Disability Program Manager for the Transportation Security Administration.
And I'm Kendra Duckworth, the Disability Program Manager for the Department of the Air Force.
Welcome to our training today on reasonable accommodations. Today, we're going to give you a little bit of an overview of the sessions. First, we're going to start out and do a legal overview, looking at the laws that pertain to reasonable accommodations and all aspects of disability. Next, we're going to provide a basic overview of the reasonable accommodation process and how it would impact you in the workplace. Then, we're going to look at the interactive process and how that works for you and what you really need to keep in mind when dealing with reasonable accommodations. Now, just kind of looking at the legal overview, here we have a picture. These individuals in this picture are probably the pioneers for all of the disability rights movement that we had in the United States. These are individuals that are actually marching to help pass the ADA, or the Americans with Disabilities Act. So how does the disability law, how is it developed? Well, initially we had the Rehabilitation Act of 1973, which said that the federal government will become a model employer for individuals with disabilities, and that agencies should give full consideration in the hiring, placement, and advancement of qualified individuals with mental and physical disabilities. Now, within the Rehabilitation Act of 1973, there are four main sections, which we'll touch on the next slide, that have specific areas that they address. The next is probably one of the biggest pieces of legislation for individuals with disabilities, and that was the Americans with Disabilities Act of 1990. Then we have an executive order that was passed in July of 2010 that really shaped how we are hiring individuals and increasing the hiring of individuals with disabilities in the federal government. And then last, we will touch a little bit on the ADA Amendments Act of 2008, or ADAAA as a lot of people call it, which definitely reshaped the Rehabilitation Act for the federal government. So the Rehabilitation Act of 1973, as it was amended, as I said, there are four main sections that we focus on. The first is Section 501, which requires affirmative action and non-discrimination in the employment by federal agencies in the executive branch. Now, recently, we had some updates to Section 501 that was done by the EEOC and OPM, and they are definitely going to reshape how we look at individuals with disabilities. The affirmative action, it's one of the only ways now for us to increase the hiring of individuals with disabilities. Individuals with disabilities is the only category we can have affirmative action plans. Now, how does that relate to reasonable accommodations? It also increased the use of personal assistance services within federal agencies for individuals with disabilities, and also required a lot more tracking of reasonable accommodations so that agencies can better report how it is that they are accommodating individuals with disabilities, which will help in the retention of individuals with disabilities at federal agencies. The next is Section 503, which deals mainly with contractors and subcontractors. But it requires the contracting companies to have affirmative action and prohibits them from employment discrimination of contractors. So it deals with any contractor or subcontractor that has a contract more than $10,000. Now, with Section 503, what it has done is it required agencies to have a 7% goal of individuals with disabilities. So it said their entire workforce needs to be 7% of individuals with disabilities. So that will help in our hiring of individuals with disabilities as well, because we may find that there are contractors with disabilities that could be hired through non-competitive hiring authorities into federal positions. Section 504 states that no qualified individual with a disability in the United States shall be excluded from, denied the benefits of, or be subjected to discrimination under any program or activity that either receives federal financial assistance or is conducted by any executive agency or the United States Postal Service. So Section 504 is the main area where we deal with reasonable accommodations because we cannot discriminate against individuals with disabilities based on 504. It requires us to also provide reasonable accommodations in any area that is receiving federal funding for not only individuals with disabilities that work for the federal government, but also programs that may have some aspect where individuals with disabilities have to use it. So I work for TSA, the Transportation Security Administration. We deal a lot with Section 504, not only with our employees, but also with the traveling public, where we have to provide reasonable accommodations for them when they're going through the screening process. Another area that has a major impact for individuals with disabilities is Section 508 of the Rehabilitation Act of 1973. It established requirements for electronic and information technology that is either developed, maintained, procured, or used by the federal government. Section 508 requires federal electronic and information technology to be accessible to people with disabilities, including employees and members of the public. So anything that we deal with that is electronic, our websites, any trainings that we produce, whether they are online trainings or they are in-person trainings if they deal with electronic information, or any programs that we develop, handouts, manuals, anything that we put online or on our websites must be accessible. And when I say accessible, they must be accessible for assistive technology. So individuals that may be using screen reading software, maybe using dictation software, they need to be accessible to those type of programs so that they are able to access them. Another area that has a big component of being accessible is when we're looking at hiring individuals with disabilities and we're using electronic applications. We want to make sure that those are accessible as well, because if they're not accessible, then individuals with disabilities would not have the ability to be able to apply for jobs. Ultimately, what Section 508 does for individuals with disabilities is it gives them access in a world now that is based on electronics. Everything that we use now has some type of electronic component. So Section 508 is one of the best pieces of the Rehabilitation Act for individuals with disabilities. Now, the Rehabilitation Act, just in general, prohibits the discrimination on the basis of disability by the federal government, federal contractors, and anyone that receives federal financial assistance. So what it does is it ultimately protects individuals with disabilities from discrimination. Not only employees, but individuals that need to utilize services that the federal government provides. It requires employers to provide reasonable accommodations to qualified applicants and employees with disabilities where it is needed. So, not only employees in allowing them to perform the essential functions, but also applicants if they need to have access to the application process, if they need to have access to interviews. The Rehabilitation Act covers them and makes sure that they are provided those reasonable accommodations. It requires federal agencies to establish affirmative action programs for the hiring and advancement and retentions of individuals with disabilities. Hopefully this new affirmative action plan that the federal government has enacted will continue the increased hiring of individuals with disabilities. We had a lot of success over the last 5 to 8 years in the hiring of individuals with disabilities, and hopefully we can continue that with the new guidelines and guidance on the Section 501 of the Rehabilitation Act. The Rehabilitation Act also prohibits employers from making improper disability-related inquiries or requiring improper medical examinations. So, agencies only need to be requesting medical documentation when it is consistent with business necessity. So it is something that they need to determine, is there a disability that will prevent someone from being able to do the job, or is it needed for them, is the medical documentation needed in determining if a reasonable accommodation is required. The Rehabilitation Act also requires employers to keep medical information of all employees confidential. We cannot be providing medical documentation or medical information about any employee or applicant to anyone in the agency. There is a need to know when it comes to medical information, and usually within the reasonable accommodation process, it is only for individuals that are making a decision. They are the ones that should have access to the medical information. So we strongly recommend not providing that information to anyone if they don't have a need to know. Also be careful of just not leaving it out on a desk or leaving it in an unlocked cabinet. We want to make sure that it is kept completely confidential. The Rehabilitation Act also requires employers comply with anti-harassment standards and prohibits retaliation by employers against individuals with disabilities because maybe they've filed an EEO complaint based on the disability discrimination or based on the fact that they haven't received a reasonable accommodation. So individuals with disabilities are also covered in the Rehabilitation Act for those areas as well. Now here I have one scenario that we just kind of want to talk a little bit about that kind of give you a little bit of an understanding about the legal aspects. So for scenario one, Mandy recently made a request for a schedule change because of her disability. The reasonable accommodation request was granted by her second line supervisor. Her first line supervisor, Jim, is unhappy because he wants all of his team members to work the same schedule. Jim threatens Mandy with a less favorable performance appraisal or demotion unless she forgoes the accommodation. So do you think that Jim's actions are a violation of the Rehabilitation Act? Why or why not? I'll give you a second to think about that. So ultimately, his actions are a violation of the Rehabilitation Act because Mandy did request a reasonable accommodation to her second line supervisor, who is someone that is in her chain of command. And based on the scenario, we do make some assumptions, but I would assume that making schedule adjustments, that is, reasonable accommodation. It is reasonable, to expect or to provide a schedule change. Her manager just wants his employees all to work the same schedule. What is that? Why is that? Is it something that is required for the position? If not, then, it's something that can be provided as a reasonable accommodation. So ultimately, yes, he is violating the Rehabilitation Act because he is trying to rescind or even retaliate against Mandy for requesting a reasonable accommodation and being provided that reasonable accommodation. So next, we have Executive Order 13164. So this executive order is the main executive order when talking about reasonable accommodations because it requires all federal agencies to establish procedures to facilitate the provision of reasonable accommodation. Ultimately, in order for the Rehabilitation Act and the federal government to really promote themselves as a model workplace, you need to have written reasonable accommodation procedures in place, and you need to be following them. Here at the State Department, you have reasonable accommodation procedures in place. I strongly recommend you talk with the Office of Civil Rights, your Reasonable Accommodation Office, because that is who enforces the reasonable accommodation process. Now, within the executive order, it outlined that the reasonable accommodations must be provided in 3 areas. To individuals with disabilities in the application process, so giving them access to not only applying for a job, but interviewing and then being brought on into a federal agency. It also requires that federal employees with disabilities be provided reasonable accommodations to assist them in performing the essential functions of the position. So that's allowing the individual to do the main aspects of their job. And we'll touch a little bit more about essential functions as we move forward in this training. And then the last area is allowing federal employees with disabilities to enjoy the benefits and privileges of employment equal to those enjoyed by employees without disabilities. Now, what are benefits and privileges of employment? So most of you work in the federal agencies. You may have a fitness center in your office. Is it accessible? Can individuals with physical disabilities be able to access that? If the fitness center is providing yoga classes or other classes, and you have an employee that is deaf or hard of hearing and needs an interpreter, are they providing an interpreter for those? If you're doing, you have a cafeteria, you have a credit union, again, are those accessible? Are individuals, federal employees, are they able to access those facilities and then be able to perform the same functions any other employees would be provided when accessing them? Another area that people probably don't really think about is, holiday parties or parties in general for, all employees. If you're going out to a restaurant and taking your entire office out to a restaurant for a holiday party to celebrate the holiday, do you need to make sure it's accessible? Do you need to make sure that if you have an employee that is deaf that needs an interpreter, do you bring an interpreter with you? Yes, you do, because all of your employees are being given access to this party. So you want to make sure your employees with disabilities also have access to that. So that's really what we're talking about when we're talking about benefits and privileges of employment.
So Michael, equal benefits also includes equal opportunity to training. Individuals with disabilities are often left out of training opportunities because of their need for reasonable accommodation. Section 501 specifically requires us to provide access to training opportunities that include providing reasonable accommodation for individuals with disabilities.
Thank you for that, Kendra. Appreciate it. So that was more about the executive order. Next, we're going to look at the ADA Amendments Act of 2008, which ultimately expanded the definition of disability and called for a broader coverage, mainly because there were some court cases that narrowed the scope of disability so much that individuals with disabilities were not being considered individuals with disabilities and were not being provided reasonable accommodations. So the ADA Amendments Act of 2008 said that an impairment that is episodic or in remission is a disability if it would significantly limit a major life activity when active. It also made sure that disability determinations would be made without considering mitigating measures other than ordinary eyeglasses or contact lenses. Now, when we look at mitigating measures, we're talking about any type of device or medication that is helping an individual with a disability deal with or maintain their disability. So if you look at someone that's in a wheelchair, you would consider the mitigating measure as the wheelchair. Someone that has a prosthetic limb, whether it's a leg or an arm, you would consider the prosthesis as that mitigating measure. So you really have to look at the individual without that measure to determine if they have a disability. Or someone that's taking medication to control a psychiatric disability or a learning disability. We would have to make a disability determination based on how they would be able to function without those medications or those mitigating measures. Also, under the ADA Amendments Act, it provided protection under the regarded as having a disability, which ultimately, said that if someone is regarded as having a disability, regardless if they have a disability or not, they would be covered under the ADA if an adverse action was taken against them. We also now look at if someone has a record of an impairment or is being regarded as having an impairment of a disability alone, it's not sufficient justification to provide a reasonable accommodation. So the individual will still have to show that they have a disability and there is a need for a reasonable accommodation. The ADA Amendments Act also expanded the definition of major life activities, which we'll touch on a little bit more when we start talking more about reasonable accommodations. So reasonable accommodations, what is it? Well, federal agencies ultimately are required to make reasonable accommodations to the known physical and mental limitations of an otherwise qualified individual with a disability, unless the agency can show that the accommodation would cause undue hardship or be a direct threat. Now, we will touch a little bit more on undue hardship as we go further into the training. And now I'm going to turn it over to Kendra.
Thank you, Michael. So now let's talk about the nuts and bolts of reasonable accommodation. But first of all, we need to understand a little bit more about what is a disability. Michael's already given you the legal definition of disability. So it's an individual who has a mental or physical impairment that limits a major life activity, or has a record of an impairment, or is regarded as an impairment. Remember that the Americans with Disabilities Act, Amendments Act, also expanded the definition of disability to include bodily functions as a major life activity, and health conditions that are episodic or in remission are also now considered disabilities. The reason for this was to focus the shift from what the individual's disability was to focus more on non-discrimination and reasonable accommodation. So what is a major life activity? A major life activity is any basic activity that the average person in the general population can perform with little or no difficulty. Includes things such as caring for oneself, performing manual tasks, walking, talking, seeing, hearing, speaking, sleeping, standing, working, lifting, bending, breathing, speaking, learning, concentrating. This is a non-inclusive list. There are many more things that are considered major life activities. And again, under the Americans with Disabilities Act, Amendments Act, we now include major bodily functions. And that includes functions of the immune system, normal cell growth, digestive, bowel, bladder systems, neurological systems, the respiratory systems, circulatory systems, endocrine systems, and reproductive systems. So what kind of disability would involve the inability to have normal cell growth? Well, that would be cancer. Prior to the Americans with Disabilities Act, Amendments Act, an individual who was dealing with cancer or limited due to the condition of cancer would not have been an individual with a disability and would not have been entitled to reasonable accommodations because they wouldn't have been able to show how they were substantially limited in a major life activity. So as a result of the Amendments Act, more conditions are now considered disabilities, and the coverage is broader now than it ever has been. Another term that we need to understand is who is a qualified individual with a disability. Both the Americans with Disabilities Act and the Rehabilitation Act provide protection against discrimination, but only to those people who are otherwise qualified, applicants or employees with disabilities. And this means that that individual can perform the essential functions of the job as determined by the employer with or without a reasonable accommodation. Now, I'd like to highlight that that's an or, not an and. So it's with an accommodation or without an accommodation if you don't need one. It also means that the individual is able to maintain the same performance and conduct standards as other employees. Again, the individual has to be able to perform the essential functions of the position. How do we determine what an essential function of the job is? There are several things that you can look at. First of all, the purpose and the result of the function versus the method of performing the job. Two individuals with the same job may not perform the job in the same way, but the purpose, the result of that job task is really what is going to be looked at. Whether I come into my office and work 9 to 5 sitting at a desk in front of a computer, or whether I do that from home. The method may change, and that would be the reasonable accommodation, but the result and the purpose of the position would stay the same. You also want to look at whether or not the individual actually is required to perform that job task as part of their job. Many of us have job descriptions that include job tasks that we've never performed as part of our positions. You want to look at the consequences of removing that function from the job. You may not perform the function very often, but if the one time that you don't perform that function, what would be the consequence? I think the good way to highlight this is the job functions of an airline pilot. Their job is 90% of their job revolves around flying the plane. Only a very small portion of that job is actually related to landing the plane. But landing the plane is a very important part of the job, and the consequences of not doing that part of the job would be catastrophic. You also can look at the percentage of the time that job function is being performed. Again, pilot doesn't spend a lot of time landing a plane, but it's an important function of that job. One way to determine what is an essential function of your job is to take a look at your job description, assuming that they are up to date and reflect the current functions of that position. You also can look at specialized skills that may be needed to perform the job function. If the individual has to have specific certifications or licenses, that would be an essential function of the position as well. Reasonable accommodation is defined as any change in the work environment or in the way things are customarily done that would enable an individual with a disability to enjoy equal employment opportunities. Some examples of reasonable accommodation would be a change in shift, providing readers, interpreters, modifying equipment, providing flexible times when an individual may take a break, adjusting job functions or job assignments, or even reassignment to a vacant position if the individual is not able to perform the essential functions of their current position with reasonable accommodation. So what is not a reasonable accommodation? Well, removing an essential function of a job is not a reasonable accommodation. Also, creating a new job is not a reasonable accommodation. Reassigning other employees would not be a reasonable accommodation. Changing productivity standards or conduct standards or removing a supervisor is also not a reasonable accommodation. And employers are not required to provide personal use items such as eyeglasses or hearing aids as a reasonable accommodation. So some examples of reasonable accommodation include making your existing facilities accessible, job restructuring. Job restructuring is something that we talked a lot about when the Americans with Disabilities Act was passed. We don't discuss this as much as reasonable accommodation so much anymore, but I think we have a lot more workplace flexibilities now than we did in the 90s when the ADA was enacted. So job restructuring means eliminating parts of the job that are not essential so that the individual is only performing those essential functions, or transferring non-essential functions of the job to another employee so that the individual with the disability then would take on some other duties that they are able to perform. One good example of this would be a position that requires the individual to make copies, multiple copies. If the individual's job is to be an editor or to create training material, using a copier may not be an essential function of the job. If you're an individual with a disability, you may have difficulty using a copier. So that part of that job could be restructured so that another individual would be responsible for actually making the copies of the training materials, while the individual with a disability would focus on the creation and the editing of those training materials. Other types of accommodation include modified schedules, acquiring or modifying equipment. Most often I think employers think reasonable accommodations are very expensive because they require expensive or very technical types of equipment, and this is often just not the case at all. Reasonable accommodation also includes modifying test exams in training materials or policies related to testing. This doesn't mean eliminating the requirement for testing, it just means modifying the way the test is given. For an individual with a learning disability who may have difficulty taking a timed test that requires reading, providing the test orally can be a modification to the testing exam, or providing additional time for the person to complete the test could be a reasonable accommodation. Of course, providing qualified readers and interpreters would be a reasonable accommodation. And then ultimately, if the individual is unable to be accommodated in the position they're currently in, then reassignment to another position is a reasonable accommodation that needs to be considered, and it's often called the accommodation of last resort. At that point, you would look at your policies for reassigning an individual to a vacant position. So let's do scenario 2, and I think Michael's going to do this for us.
Thank you, Kendra. So looking at scenario 2, we're going to just talk a little bit and kind of really look at what it is we would need to do for an individual with a disability. So Bob, an employee with a visual disability, can no longer drive. As a result, Bob seeks a reasonable accommodation at work. He explains to his supervisor, Linda, that he can no longer drive to work and informs her that the facility cannot be accessed by public transportation. Linda explains to Bob that because his job cannot be done from home, telework is not an option. What options do you think are available? Can the agency also consider termination? So I'll give you a second to think about those two questions. Okay, so looking at this scenario, what options are available? Is it really true that telework cannot be done for this position? Maybe looking at providing Bob with a personal assistant service that can drive him from the local public transportation stop, whether it's a metro stop or a bus stop. Maybe that could be an option. The agency could work to provide someone to be able to do that. Maybe Bob isn't able to telework 5 days a week, but maybe he can telework 1 or 2 days a week to provide that as an option to really see what can be done. Now, looking at, can the agency consider termination? Not necessarily in this situation. Ultimately, they have to exhaust all the other reasonable accommodation options, including reassignment. So maybe we need to look at, does the agency provide a reassignment to another position for Bob to allow him to be able to telework from home? Now, just some things to keep in mind when thinking about reasonable accommodation. Low-tech, no-tech options can be just as effective as, technology or other options that may be expensive. A lot of times individuals may be requesting, a full new computer hardware setup, when maybe all they need to do is download a specific program or an app to a mobile device or a tablet that would allow them to be able to do their job. Also, it's not required to provide the exact accommodation that the individual with a disability has requested. Ultimately, you have to provide the most effective accommodation. Also, the accommodation that removes the barrier from allowing the individual to perform the essential functions. So just because an employee requests something doesn't necessarily mean that's what the agency has to provide. Also, keep in mind that there are a lot of resources out there that you can take advantage of to allow you to determine what is the best accommodation to be provided for the employee with a disability. You have resources like the Job Accommodation Network, JAN. They provide a plethora of information about different types of accommodations that may be able to be provided to an individual with a disability. They don't have the ability to be able to provide, resources in terms of physical resources like technology or buying equipment, but they can give you advice and guidance to help you make the most informed decision. You also have resources like the Computer Electronic Accommodation Program, which provides assistive technology free of charge to federal employees, including State Department employees. They do have the ability to do a needs assessment to determine what types of electronic or assistive technology would be needed for the individual, and then they can go from there to working with the individual to procure it for the agency, and then also work with the agency to make sure that it is installed properly and implemented appropriately. You also have the State Department's Assistive Technology Resource Center that are located all across the country and across the world, and they can provide resources as well in assistive technology. So just keep in mind that just because you think something is going to be expensive, that you still may have to provide it if it is expensive, but there are other options out there that allow the individual to be able to perform the job through the reasonable accommodation process. So now, let's look at another scenario. After a surgical procedure left Valerie, a service representative, with a vocal cord dysfunction that prohibited her from talking more than 15 minutes per day, she asked her manager to only assign her written correspondence. So first and foremost, is this a reasonable accommodation request? Yes, it is. It is a reasonable accommodation request. Now, would the requested accommodation be reasonable and or effective? Now, ultimately with this scenario, we would have to really look more at what are the functions of her job as a service representative. Most customer service representatives, they probably are dealing a lot with telephone work, where they are corresponding over the telephone. But there may be some customer service representatives where maybe they're only answering email correspondence or mail correspondence. So if that's the case, maybe we would look at providing her with a position that allows her to only do those type of functions, and she would only answer calls for a small portion of the day. So, ultimately, what should the agency do? They really need to look at her position, look at the essential functions of her position, and determine, is talking for more than 15 minutes per day really essential to her job? And once they've determined that, then they can really figure out what is the most effective accommodation that can be provided. So what is undue hardship? As I said earlier, for reasonable accommodations, federal agencies are required to provide reasonable accommodations unless doing so would cause an undue hardship. So there may be specific accommodations that would require significant difficulty or expense to the agency, and that ultimately is what undue hardship is. Now, when looking at undue hardship, for most agencies, they have a specific process in determining whether or not undue hardship is present and they're not able to provide the reasonable accommodation because of it. Some considerations that you should include is the overall size of the agency, the type of the operation of the agency, what is the core mission of the agency, and how would the reasonable accommodation impact that, the nature and cost of the accommodation. Now, I will say, majority of the time, cost is not a very good reason for denying reasonable accommodations. And the reason why that is because if at any point an EEO complaint is filed and it goes through the court process, ultimately the court is going to look at the budget of the department that the agency is in. So they would ultimately look at the budget of the State Department, which I'm assuming is a very large budget in the billions of dollars. So to say that you can't provide an accommodation that is $1,000, $5,000, is going to be very difficult considering the budget of the State Department. Overall financial resources, yes, I understand in these times and within federal agencies, there's different types of resources or financial structures, but ultimately, it would be the office's responsibility to pay for the reasonable accommodation. And if the office is not able to pay for it, then it would move up, whether it's a regional location and then overall the State Department. But there are also other resources out there, as I said earlier, with the Computer Electronic Accommodation Program that may be able to provide certain resources that would alleviate any expense for the accommodation. You also need to look at the impact of the accommodation on the operation of the facility. And if that would severely impact the operation of how the traditional work happens at that facility, then you may be able to say that it is going to be an undue hardship for the agency. But you want to make sure that you're making that determination based on the overall resources of the agency and workplace operations. And I would probably say an agency is not going to be successful to assert that cost is a defense. Again, most times agencies try to use the cost of an accommodation and say that it's an undue hardship, but more than likely you're not going to be successful in doing that. So I would say that you really need to determine how it is that you're going to pay for the accommodation instead of saying that you're not going to be able to pay for it. Now let's look at another scenario. So here we have Anne. Anne is a qualified individual who is deaf. She applies for a policy advisor position with the Navy. The position involves participating in many meetings and making presentations both in and out of town, and would use a sign language interpreter on a regular basis in the position. So, first question we have is, would providing a full-time interpreter constitute an undue hardship? And what about during business travel? Would an interpreter be required while on business travel? So I'll let you think about that for a second. So for this scenario, the first question, would providing a full-time interpreter constitute an undue hardship? I would say no, mainly because there are a lot of individuals that have full-time interpreters for them when they're working, but her position would require her to attend meetings both in and out of town, so it seems like she's going to do a lot of traveling. So more than likely she's going to need an interpreter for majority of these meetings. So, there is definitely a need for it, and providing a full-time interpreter can be provided through a special hiring authority where you can hire someone specifically to do interpretation for this individual. So, more than likely it's not going to be considered an undue hardship. And then also while on business travel, yes, Section 501 of the Rehabilitation Act does require that we provide these type of services for individuals with disabilities even while they're on business travel. Next, I'm going to turn it over to Kendra to talk a little bit more about the interactive process.
So the interactive process is basically just a communication between the individual with the disability and their manager and supervisor. This is the time when the manager is going to ask relevant questions that enable the individual to make a decision regarding what reasonable accommodations are going to be necessary in this specific situation. Many managers and supervisors are afraid to ask questions when an individual requests reasonable accommodation. And this is really your opportunity to do that, to ask questions regarding what is the individual's disability, what accommodation they're looking for, and why they need that accommodation. So the interactive process begins with a reasonable accommodation request. And at that point, you want to begin a dialogue to talk about specific things. It's important to acknowledge that the individual has requested a reasonable accommodation and identify the specific requirements. What type of software is this person looking for? Is there a device or a modification in policy that they're requesting? You need to identify how this accommodation will enable the individual to perform the essential functions of the position. This is a good time to consult with your agency resources, whether it's your accommodation resource person or your EO person, and then determine whether or not the individual actually has a disability. This is where you want to request medical documentation, but remember, you can only request medical documentation when the need for the accommodation is not obvious. So if an individual has an obvious disability and their need for that accommodation is readily apparent, you would not be able to request medical documentation. But I think in 90% of the cases, the need for the accommodation is not obvious, and it's okay to ask for specific medical documentation. Keep in mind that that medical documentation needs to be directed towards the individual's need for reasonable accommodation and shouldn't ask any other information that's not relevant to the accommodation request. At this point, then you want to explore your accommodation options. Keep in mind the individual with a disability is probably the best source of information on what would be the most effective reasonable accommodation. We've also talked about other resources such as the Job Accommodation Network and the Computer Electronic Accommodation Program, who can provide you with additional information on the types of accommodations that this individual may be needing. So the final step is to actually implement the accommodation. Keep in mind that the interactive process can take a series of weeks from the time the reasonable accommodation is requested until the accommodation is actually implemented. Scenario number 5. Beth has renal failure. She has exhausted all of her accrued leave and only has 4 weeks left of her FMLA leave. Beth is requesting an additional 10 weeks of leave to recuperate from kidney transplant surgery. So how would you start the interactive process? What considerations can be taken into account? And does the agency have to provide the additional leave? So the interactive process begins with her request for additional time off. Something that you would want to consider is, do you need to request medical documentation to document her need for this additional leave? What other considerations need to be taken into account? Is this an undue hardship? If Beth is the only person available to do the position, what happens if that job function is not being done for the next 10 weeks? Does your agency have the requirement to provide additional leave? Keep in mind that providing leave can be a reasonable accommodation, and that leave can be added on top of leave that the individual is entitled to under FMLA. In most situations, providing additional leave would be considered a reasonable accommodation unless the agency can show that it's an undue hardship. I think you also need to keep in mind the situation the individual is dealing with. This individual is having life-threatening surgery. Whether we grant the leave or not, the individual still has the medical need for the time off. I think most managers agree that they're willing to work with individuals to take care of their medical needs as well as perform their jobs. This may be a situation where providing temporary telework would also be a reasonable accommodation to enable Beth to recuperate from her surgery as well as perform some of the functions of her job from home. And finally, let's talk a little bit about managing individuals with disabilities. If you're a manager of an individual with a disability, it's important for you to know and understand your agency's reasonable accommodation procedures and utilize your disability program managers or your reasonable accommodation office as a resource. Those individuals are there to assist you through the interactive process. It's also important to involve the individual with a disability throughout the process of reasonable accommodation. You really can't accommodate somebody if they're not involved in that process. It's important to maintain confidentiality. Do not discuss the employee's medical documentation or condition with individuals who are not on a need-to-know basis. Also, it's important not to keep medical documentation in an individual's personnel file. All medical documentation needs to be kept separate in a separate accommodation file. You want to document the disability, the request for reasonable accommodation, what accommodations were granted, including detailed terms of agreement. If you've agreed to temporary work from home or telework, you want to document that this is a temporary agreement and indicate when that telework agreement will begin and when it will end. You want to also keep open the lines of communication with the individual with a disability to be able to address any ongoing needs. And finally, it's important not to address information related to the individual's reasonable accommodation in their performance evaluation. This is also a violation of the Rehabilitation Act. And do not ask employees for medical documentation that's not related to their request for reasonable accommodation. Scenario number 6. Ron is interviewing a candidate who has an outstanding application and credentials. But the woman is limping slightly and has not mentioned that she has a disability. Ron's a little concerned because the job requires walking between various buildings for this position. So he considers asking her questions about his concerns. So how should Ron approach this subject? And what questions do you think Ron can ask during the interview? This is a very tricky situation. You have to balance your need to know whether or not the individual can perform the essential functions with concerns over whether or not you're asking questions that are unrelated to the interview. I can tell you that during an interview, when the individual's disability is obvious, you can ask how that individual would perform the essential functions of that position. So Ron could say something to the effect of, this job requires a lot of walking. We work in a large compound. You may have to move from one office to another. Would you have difficulty doing that? That would be an appropriate question during an interview because it points to the individual's obvious disability and a need to perform the essential functions of the job. It also gives the individual the opportunity to discuss what reasonable accommodations that they may need. And finally, keep in mind that reasonable accommodation is an ongoing process rather than a one-time obligated event. Individuals with disabilities may need accommodations throughout the employment life cycle, from application to retirement. And an individual with a disability can request reasonable accommodation at any time and as often as they need it. Something that you want to keep in mind when you've provided or agreed to a reasonable accommodation is periodically check to make sure this accommodation is still working. Is the individual enabled to perform those essential functions of the job? Does this accommodation need to be tweaked? If the individual's been teleworking 2 days a week and they may need to extend the number of days that they're working from home. Or if you've implemented software, maybe the software needs to be updated so that it's more efficient with your computer system. Does this individual need training? Oftentimes, reasonable accommodation does involve new technology. And if you're like me, it takes me a while to learn how to use new technology. So an individual may need training on how to effectively use the technology so that it is actually an effective reasonable accommodation. Also, you want to keep in mind whether or not the disability or the work environment has changed over time. Individuals' disabilities often do change over time depending on their condition, and also work environments change. The job duties may have changed, or the environment that they're working in may have changed. All of these things can affect whether or not the accommodation continues to be reasonable and effective for that individual. That concludes our training today. If you have additional questions, you can contact the Office of Accessibility and Accommodations.
Or the Office of Civil Rights. Thank you for participating in the training. We hope you enjoyed it.
Hi, my name is Glenn Budd. I'm the Chief of the Intake and Resolution Section in the Department's Office of Civil Rights. I've been asked to come and speak with you this morning about retaliation and more specifically, per se reprisal violations. I'd also like to thank my esteemed colleagues, Ms. Kendra Duckworth and Mr. Michael Looney, for participating in this training session. As we talk about retaliation, I think it's necessary that I mention that currently retaliation comprises 40% of all EEO complaints that are raised at the Department of State. And it is the dog that gets off the porch most frequently and bites you the hardest. And what I mean by that is when we have findings of discrimination made against the Department of State, it is almost always reprisal, and that is the case across the federal government. Number two at the Department of State are findings of discrimination based upon denial of reasonable accommodation. So in other words, when the department loses, it is almost always these two bases of discrimination. I need to tell you what retaliation is. Retaliation is negative treatment or making decisions against an employee who engaged in any protected EEO activity. That would include speaking with an EEO counselor, participating in a harassment investigation, or filing an EEO complaint. It could be also that you served as a witness in somebody else's EEO complaint, or you may even have been a responding management official in an EEO complaint for someone else. But again, doing that is completely inappropriate, and actions are taken against managers and supervisors who participate in retaliation against employees. So let's talk a little bit about an unlawful chilling effect. That's something that's pretty easy to run afoul of. As supervisors and managers, all supervisors and managers or people in a position of authority are prohibited from doing anything that would have a chilling effect on whether or not somebody would feel likely or unlikely to participate in that protected EEO activity that we just discussed. It could be as simple as, say, you worked for me and you went and see an EEO counselor, and I called you into my office and said, look, I don't appreciate that you went to see an EEO counselor. You should have come and spoken to me first. That is enough to consist of per se reprisal violation. Sometimes we see stronger acts of per se reprisal violations. I'll give you an example that we saw here at the Department of State this year that resulted in a finding of discrimination. We had a management official that shared the affidavit that had been provided by an EEO investigator with other colleagues, other supervisors, and other employees where she was responding to an official EEO investigation. That's actually illegal. It led to a finding of discrimination against the Department of State. And as supervisors and managers, it is something that we would want to avoid. The same supervisor took some further steps and mentioned her displeasure about a particular individual filing an EEO complaint. That would very clearly have a chilling effect on whether or not somebody would participate in protected EEO activity. You just can't do it. And every time that comes to light and it makes its way before an EEOC administrative judge, that judge will make that finding of discrimination against the Department of State for a per se reprisal violation, or taking actions that would have a chilling effect on whether or not somebody would participate in that protected EEO activity that we've been discussing. One example that I can mention is at a previous agency that I worked at, we had a situation where a supervisor, and it was a law enforcement type agency, a supervisor, before their regularly held morning roll call, would say words to the effect of, "So-and-so is in the room today. We know that this gentleman is very sensitive. We wouldn't want to do anything that hurt his feelings. We know how sensitive he is. We wouldn't want him to feel the necessity to run back down to the Equal Opportunity Office again and cry to the Equal Opportunity Officer." So those are the type of things that we would want to avoid. And as an aside, this same individual, and I worked on this case, this same individual on a particular day came in and removed a round from his service weapon and laid it on the individual's desk and used words to the effect of, "You should take this round and do yourself, your colleagues, and certainly me a favor and use it to off yourself." And that individual put himself right in the line of fire himself. He took actions that led to his removal from his position, and it's completely avoidable. My former boss, Director John Robinson, the former EEO director here at the Department of State, would refer to reprisal, and specifically per se reprisal, as a self-inflicted wound. He would say that it was akin to putting the bullets in the gun that would be used against you, and it's completely avoidable. If you're a supervisor and a manager and you're hearing my voice as part of this presentation, I am the only bud in the locator. Please pick up the phone and call me, and I will talk you back from the edge of the abyss before you step into it. It is avoidable. It is illegal to take acts like this, and you should rethink before you commit anything that would look like a per se reprisal violation. There are a number of examples other than the ones that I used. It could be that a person provides false information to an EEO counselor. The 29 Code of Federal Regulations dictates that all managers and supervisors at agencies have to cooperate with EEO counselors and investigators. We can be sanctioned just for not cooperating with an EEO counselor or an investigator. It's not a choice. It's actually an obligation, and it's your job, if you're a manager and a supervisor, to make sure that you articulate for the department your legitimate non-discriminatory reasons for any actions that you've taken. So you do have to cooperate with EEO counselors, EEO officers, and EEO investigators. And that obligation would follow you even after you leave the Department of State. They can compel you to come back and cooperate with counselors and investigators if you are still working for the federal government in some capacity at any time. Even if the employee no longer works for the department, we can still compel that testimony. So if you have questions on that, I want you to feel free to call me about that as well. Another example could be that a supervisor makes a joke that says an employee manages to spend half of their work time working on their EEO complaint, and they talk about it openly in a forum or staff meeting. And by the way, this is a real example that has happened here at the Department of State. That would clearly have a chilling effect on whether or not somebody would participate in protected EEO activity if they knew that they were going to be the subject of or the object of jokes or fun at a staff meet or in some other public forum. This also happened. It would be inappropriate for a supervisor to share with others a person's EEO activity. That sometimes happens on golf courses and fishing holes. At bars after hours, we are again prohibited from sharing a person's protected EEO activity. If you have questions, please call me, call the case manager, talk to the EEO counselor, talk to somebody that can help you with regard to your obligations to avoid reprisal and per se reprisal violations. Sometimes managers are under the misimpression that they cannot hold people accountable for their performance and conduct. That is not true. You can still continue to hold people accountable for their performance and conduct, but you cannot do that as a knee-jerk reaction for somebody filing an EEO complaint. If you're a manager and a supervisor, I recommend when you come on board as a manager and a supervisor that you set very clear expectations. You set strong, measurable work commitments, and you hold people accountable across the board without regard to their protected EEO activity. Don't wait until 15 or 20 minutes after they file an EEO complaint to hold somebody accountable for their performance and conduct, because it again is going to look very much like an act of reprisal. I have been doing this a long time, 22 years I think, and in one particular case I saw that a supervisor put in a person's EER that they operated well enough within the constraints of their multiple EEO complaints. You never want to refer to that activity in anybody's EER. That's not in keeping with good HR standards and should be strenuously avoided. Again, talk to your HRO, talk to whoever your HR official is, pick up the phone and call me, and I'm happy to help you with anything that's related in the EEO field and your obligations as a supervisor and a manager. Or if you have questions for me as an equal opportunity officer here at the Department of State. If you have, again, questions, you can reach out directly to SOCR, the State Department's Office of Civil Rights, and we are available on our website, and the main line to our office is 202-647-9295. Thank you again for your time today.